fast and getting to the point. Thank you so much. Wonderful. Next, I'd like to introduce Pia Flanagan. Pia is a partner with Baker McKenzie. She's an expert on employee benefits and executive compensation. And she is going to talk about several aspects of this, but remind us about HIPAA and some responsibilities there, and the HITECH Act. So, Pia.
Good morning, everyone. As the attorney on the panel, I was very pleased to see everyone having a cup of coffee this morning, because you may need them to get through these regulations I'm going to discuss. So I'm going to discuss some of the requirements under the recently issued regulations under healthcare reform's pay-or-play rules that were issued this past December in proposed form, as well as the final regulations under HIPAA that were issued this past January. Mike has touched on some of the things that I was going to speak about with respect to pay-or-play, but what I do want to focus on this morning is how do you determine if you are a large employer that will be subject to the pay-or-play rules? And more specifically, how do you identify your full-time employees? I'll ask you to keep in mind that these rules are very complex in detail, so we're not going to have a chance to go into great detail this morning, but I would like to just touch on some of the high points of these requirements. So in determining whether you are a large employer that is subject to the pay-or-play rules, you look at your full-time employee workforce. So if you employed an average of at least 50 employees, full-time employees, on business days during the prior calendar year, you will be subject to these pay-or-play requirements. And the proposed guidance tells us that this will be determined on a controlled group basis. So for example, if you are a small company that only has, say, 10 full-time employees, but you are a member of a larger control group of organizations that has in excess of 50 full-time employees on a combined basis, you will be subject to these pay-or-play rules as a member of an applicable large employer group, in spite of the fact that you yourself only have 10 full-time employees. Now, the good news for you is that the penalties will be assessed on an employer-by-employer basis. So when determining the amount of any penalty that you may owe, you would only base that penalty calculation on your 10 full-time employees and not the combined total number of full-time employees of the controlled group. And full-time for these purposes means not only your full-time employees who work in excess of 30 hours per week, but also your full-time equivalents, which would include your part-timers, temporary employees who work less than 30 hours per week. So you have to look at your full-time employees, and you have to combine the hours of your full-time equivalents, divide that number by 120 to get the total number of your FTEs, add that with your full-time employees to determine how many employees you have, to determine then whether you will be subject to the pay-or-play rule. So if those two numbers combined is at least 50, you will be subject to the pay-or-play rules. And as Mike touched upon earlier, when calculating your penalty amounts, you only look at your full-time employees and not your full-time equivalents. So you're only using your full-time equivalents to get you to whether or not you're going to be a large employer. They don't come into play when determining the amount of your penalties. One of the other things that the proposed guidance provides is guidance to employers who hire seasonal workers. Again, we don't have time to go into these complex, very detailed regulations, but I just wanted to point that out because some of you may be in the retail industry, hospitality industry, restaurant industry, where you employ seasonal workers. Maybe during the holiday season you need additional employees. Well, the proposed regulations provide some flexibility for you in counting these employees to determine if you get to that 50 full-time employee threshold, whereby you will be considered a large employer. The proposed regulations also provide some special transition relief for determining your large employer status for the 2014 year. So here we are, March 2013. We're just now getting this guidance. There's still additional guidance to come. Employers are trying to get a handle on these regulations. They don't necessarily want to wait until the end of 2013 to determine whether they are a large employer for budgeting purposes, for purposes of determining whether they may choose to pay or play. So these proposed regulations essentially give you the opportunity or the option to elect to determine your large employer status on any 6 consecutive month period during 2013. So for example, you can choose to look at the period March through September of 2013. and use that period to determine whether or not you meet this 50 employee threshold. At least that way you'll have a few months at the end of 2013 to make some final decisions going forward for the 2014 plan year. One of the things under the regulations, they walk you through how to identify your full-time employees. And it's a little confusing, even for myself, because you have to look at your full-time employees for 3 separate and distinct purposes under these regulations. The first is for purposes of determining your large employer status, which we just discussed. Secondly, full-time employee determination is important because that is the group of employees to whom you must offer coverage in order to try to escape some of these penalties. And lastly, your full-time employee count is important because your penalty calculation is based on the number of your full-time employees. And for each of these purposes, the full-time employee is defined, or employee rather, is defined using a common law definition, which essentially means if you're an employer and you direct and control that employee's work, you typically would count them as a common law employee. So you would exclude your independent contractors. If you're a partnership, you would exclude partners in your partnership, 2% shareholders in an S corporation, self-employed people, as well as leased employees. And as I mentioned, full-time for this purpose means employees that are employed an average of at least 30 hours of service per week, or you are permitted to use a 130 hours of service per month equivalent. To determine your hours of service, the regulations look towards the qualified plan definition, which generally means that you count not only hours for which work is performed, but also hours for which work is paid or a person is entitled to payment, even when no work is performed. So you would count hours spent for vacation, illness, sick days, and the like. One of the other things that's sort of a gimme for a lot of corporations that have operations outside of the U.S. is that you do not have to count hours of service performed outside of the U.S. So if you are a member of a control group of corporations with foreign entities as members of your control group, or if you have a large expatriate population of employees, their hours performed outside of the U.S. will not be counted when determining whether you are a large employer or when determining the amount of any penalty or determining the employee population to whom you must offer coverage under these rules. Lastly, with respect to identifying your full-time employees, since you determine this on a monthly basis, and that is subject to constant fluctuation, the proposed regulations provide that you can use a 3 to 12 month look-back measurement period when determining your full-time employees. But this is strictly for purposes of coverage and penalty determinations only, and not for purposes of determining your large employer status. And again, I hate to keep saying these rules are complex and detailed, but they are. And I would really encourage you to look towards the regulations, look towards your legal counsel and your benefits consultants, excuse me, to get a better understanding of these rules, because they differ whether you have union versus non-union employees, whether you have temporary workers, seasonal workers, if you are a new employer, if you have new employees joining your workforce group, there are different rules for ongoing employees. So you really need to look to these rules and regulations to gain a better understanding of how they may apply to your specific business. Now, it is possible that you can offer coverage that can escape or avoid the excise tax. And Mike went into some of these rules. So for instance, if you offer coverage to all of your full-time employees, and minimum essential coverage is the key word here, you can potentially escape the excise tax. Minimum essential coverage is not defined under the plan, except to say that right now it includes coverage under your employer group health plans, as well as any governmental plan or individual policy. And you also have to cover your dependents as of 2015. That is a requirement under these rules as well, or you will be penalized for failure to offer coverage to the dependents of your full-time employees. As Mike mentioned, you can escape these penalties potentially if your coverage is both affordable and it provides minimum value. And to be affordable, you look to the 9.5% of your employee's household income. Now, it's impossible for an employer to know an employee's household income, so the IRS provides a safe harbor in saying that you can look at the employee's Form W-2 Box 1 wages to determine affordability. And in terms of providing minimum value, there's a 60% test. If your plan pays at least 60% of the cost of benefits, you will be considered as providing minimum value. We do expect future regulations and guidance on that issue, but for now, they will provide, the IRS and the Department of Health and Human Services will provide an online calculator for your use in determining minimum value. So I'm not going to get into calculating the penalty because Mike touched upon that, but as it relates to healthcare reform, I would just caution you to, again, carefully, review the regulations with either your legal counsel or your benefits consultants because they are pretty detailed and complex. They are also in proposed form, and the comment period just ended this past March 18th. So expect future clarifications, modifications, and other guidance in respect to these proposed regulations. Next, I want to quickly give you 4 key takeaways for plan sponsors under HIPAA and HITAC, and specifically the final regulations that were issued on January 25th. And these all pertain to really documentary and administrative processes for employers. So the first is you will need to update your breach notification standard as a result of modifications to this under the final regulations. The final rules adopt a more uniformed and objective standard, and they essentially provide that a breach of unsecured PHI will be deemed to occur, will be presumed to have occurred if there is an impermissible use or disclosure of PHI. So it's presumed to be a breach. So the onus is now on the covered entity or the business associate to do their 4-factor risk assessment test to determine that a breach has not occurred. And in order for that to happen, this test has to show that there is a low probability that the PHI of your employees has been compromised. To the extent that you go through this test, and let's say you have to give notice not only to individuals but to the Department of Health and Human Services as well as to the media, the regulations do provide a new safe harbor or a new rule in terms of providing notice to the media. Previously, you had to provide notice to a major, news outlet or newspaper. Now you only have to provide a press release to the media. So I know we have employers who have been in this situation, and it costs them a lot of money to publish notice in a newspaper. Now all you have to do is send a press release to the media. What they do with it is not any of your concern. As long as you publish or provide that press release to the media, you have nothing else to worry about. You've met your obligations under these new standards. You do have to comply using this new standard by September 23rd of this year. So for any breaches occurring up through and including September 22nd, you can use the old HIPAA breach notification rules to comply with your requirements, if any. The second takeaway is that you will need to amend your business associate agreements. There are new requirements under HIPAA and HITAC with respect to a business associate's obligations. Business associates are now required to comply with some of the privacy requirements, but they are now required to also comply with all of the security requirements. So they have additional obligations under the security rule. They now have to, enter into contractor agreements with their subcontractors. They now have to conduct risk assessments. They have to develop security policies and procedures, and the list goes on. But as a result of these changes that primarily impact business associates, you as a plan sponsor or a covered entity will need to amend your agreements to include these new provisions that are applicable to business associates. So you need to include in your business associate contracts the obligations of business associates to report a breach of unsecured PHI, obligations of business associates relating to their new security requirements or responsibilities under HIPAA and HITAC Act. I think a lot of clients, at least the ones that I have serviced, we tried to update their business associates when HITAC was first released back in 2010. So to the extent that you fall in that category, you may or may not have to make any further amendments to your business associate agreements. The deadline for doing this, if you have a HIPAA compliant agreement in place by January 25th of this year, you will have at least a 1-year reprieve, so until January 22nd of next year, to amend your contracts. Business associate contracts that were not in place as of January 25th, or for any new contracts that you enter into, you must include these updates in those contracts by September 23rd of this year. The third takeaway for plan sponsors is that you will also need to review and update your notice of privacy practices. I've included in your materials a list of the required updates to your notice of privacy practices, which describe, circumstances in which an individual authorization is needed, et cetera. So you will, if you could take a look at that handout, that will give you the information that you need to include in your notice of privacy practices. And because these changes are deemed material, you will be obligated to redistribute your notice of privacy practices to all of your plan participants. If you post your notice on your website, you can continue to do that as long as you post the revised notice by September 23rd, 2013. And you will also be required to provide this copy of the revised notice, or at least information on how to get that in your next annual mailing. So for calendar year plans, you would include the actual notice or information on how to get that notice in your open enrollment materials for the 2014 plan year. If you do not maintain the notice on your website, you are required to distribute this notice or information on how to obtain it within 60 days after the effective date of this change, which would be November 22nd, 2013. The last takeaway for plan sponsors under the new HIPAA and HITECH regulations is that you will also need to update and review your privacy policies and procedures. There are a number of other changes in these final regulations that I just haven't had a chance to discuss this morning, including changes to marketing, sale of PHI, use of PHI for fundraising purposes, genetic testing, access to electronic PHI, and the list goes on and on. So again, I urge you to review these regulations or consult with your counsel or benefits consultants to determine what you need to do, determine how these regulations impact your specific business, and get to making these documentary changes to your processes and procedures and your administrative options as soon as possible. Thank you.